Hello, everyone. Good evening. Uh, yeah. Okay. A warm welcome to each and every one of you joining us today at the intersection of litigation, corporate advisory, and strategic dispute resolution. Advocate Swapnil Srivastava. Before we begin, just a few reminders. Please keep your microphones on mute during the sessions and your cameras on. You're encouraged to post your questions in the chat box. We'll have a dedicated Q&A towards the end. Or towards the end, you can also raise your hands and ask your questions directly to Sir. The session is being recorded and would be available within a week or two on our YouTube platform. And in case you need to get a certificate or you wish to get a certificate for the same,
Your voice is breaking. You are not audible.
Ma'am, voice is breaking.
Yes, ma'am.
And now the video is paused.
Okay, I am so sorry about that. There's a bad network connection in my area. So let me take a moment now to introduce our esteemed speaker. Advocate Swapnil Srivastava is a senior associate at MZM Legal LLP with a robust practice spanning white-collar criminal litigation, complex commercial disputes, and strategic corporate advisory. He regularly appears before the Supreme Court of India, multiple high courts, and key tribunals such as the NCLT, NCLAT, DRT, DRAT, and PMLA adjudicating authority. Sir's expertise extends to bail and quashing petitions in white collar crime and economic offenses, pre litigation strategy in cases of data theft, bribery, and misconduct, cross border and domestic arbitration under ICC and SIAC rules, and also complex contractual and commercial litigation. Furthermore, he's also deeply engaged with pro bono work, having been associated with the Migration Asylum Project and the All India Dalit Mahila Morcha. A graduate of National Law University, Jodhpur, he has represented his institution in prestigious international moot courts, published on white collar crime and arbitration, and been a guest lecturer in criminal law. He is a regular voice on national-wide media such as Times Now and Mirror Now. It is an honor to have him with us today. Swapnil sir, the virtual stage is all yours.
Thank you, Preksha, for that kind introduction. So let us start. And before we start, let me just ask two things. Is my screen visible and am I audible to everyone?
Yes, sir.
Yes.
Perfect, perfect. So I would strongly encourage everyone to post any questions that you have during the course of this webinar in the chat box. And while we have a dedicated time slot towards the end of this webinar for question and answers, I'll also take up any questions which I feel are relevant during the course of the webinar. Just keep putting it in the chat box. Now let's start. So the topic of today's webinar is Prevention of Money Laundering Act, and in that context, balancing state powers with fundamental rights. Now, I just want to clarify that something like the PMLA is a rather complex legislation which has had quite a march of law since it's been promulgated. So we'll obviously not be able to capture everything and in an exhaustive manner during the course of this webinar. So my endeavor has been to focus on two key things. First are powers of arrest under the PMLA, which is section 19 of the Act. And the second is the bail provisions contained in section 45. And within these segments, I have focused on key case laws which has shaped the way the law stands today. So let's just start with it. First and foremost, and this is very basic, and I'm sure that everyone here is aware of what the Money Laundering Act is. It is a special legislation which is focused on the offense of money laundering. The ED investigates it, the Directorate of Enforcement, and it has far-reaching powers such as search, attachment, sale of properties, etc., to recover any tainted proceeds of income that the accused persons might have garnered through illegal activities. Now, proceeds of crime is a key concept which needs to be understood whenever we are talking about the PMLA or whenever we are talking about the powers of the ED. So, proceeds of crime basically means tainted money. It means any money which has been generated through illegal work, any money which is being shown as clean income, white money, whereas it's not in fact. Any such money is known as proceeds of crime. And the ED's jurisdiction is limited to being able to investigate only proceeds of crime. So for example, if there is an offense of fraud where banks have been duped of crores of rupees, it is not the ED that is going to investigate that offense. The ED will only be concerned with the proceeds of crime which have been generated as a consequence of such an offense. And this is very crucial because almost all the powers of the ED and the entire framework of the PMLA has been shaped in such a manner so as to aid and assist this purpose of the ED. Now, in this context, it is important to understand why the ED may require powers of arrest. So there could be a few reasons for that. Number one being facilitating investigation into proceeds of crime, like we just discussed. This can take many shapes and many forms. For example, if there is an accused person who needs to be confronted with certain incriminating evidence, or if there is a co-accused who has given certain disclosure statements which show that another accused person is guilty, then often these two people are put face to face with each other and then questions are put to them. This is something known as confrontation. So facilitating investigation into proceeds of crime. Second reason could be preventing further offenses being committed by the accused persons. This can take the form of further concealment of funds which the ED is trying to detect and investigate. This could take the form of alienating property which has been illegally acquired by the accused persons, etc. Then for securing evidence, which entails ensuring that documents are not destroyed by accused persons. Therefore, you take them in custody and then you carry on search, seizures, etc. To ensure that witnesses in the investigation are not influenced or intimidated by the accused persons, etc. And lastly is ensuring presence in court. However, these powers we must understand, and as the topic of the webinar today also indicates, must be balanced with the fundamental rights. Okay, somebody has a question which is basically, why do we call it white collar crime? Isn't crime in every aspect? Which it's true, crime is crime in every aspect. But just for everyone's clarity, it is called white collar crimes because it is referring to a specific form of crimes, which are usually financial crimes or crimes which require complex planning, conspiracy, etc. So things such as fraud, forgery, financial crimes, bribery, etc. become white collar crimes. This is compared to blue collar crimes or blood crimes such as murders, kidnappings, rapes, etc. I hope that answers the question. Just jumping back to the webinar. So now these powers of the ED to detect and to procure proceeds of crime caused as a consequence of any offense must naturally be balanced with the fundamental rights which have been guaranteed to everyone in the country. Now, primary among these fundamental rights are 20, 21, and 22 of the Indian Constitution. And we are going to take a quick look just to refresh at Article 21 and Article 22. So Article 21, everybody knows this, that no person shall be deprived of his life or personal liberty except according to procedure established by law. It's very straightforward. It means that if today I as an individual is to be deprived of any of my rights, such as my right to liberty in the cases where I'm being arrested, then such deprivation must occur as per the procedure prescribed by the law. If there is any deviation whatsoever from that procedure, then my arrest or rather my deprivation would be considered illegal and set aside. Then there's Article 22 of the Constitution, which states that no person who's arrested shall be detained in custody without being informed as soon as may be of the grounds for such arrest, nor shall he be denied the right to consult and to be defended by a legal practitioner of his choice. Now, anybody who has dabbled in criminal law knows that one of the most basic fundamental tenets of it is that if I am being accused of an offense and as a consequence thereof my liberty is being deprived, then I must be made aware of what the allegation against me is. So that is what Article 22(1) tries to capture. Now, of course, all of this basically came for discussion, for consideration before the Supreme Court in the very famous case of Vijay Madanlal Chaudhary versus Union of India. So these were a batch of petitions before the Supreme Court where the constitutionality of various provisions of the PMLA were challenged, including 19 and 45. And the Supreme Court held that the provisions are completely constitutional because the purpose which the Act is to serve, which is to detect complex financial crimes and to trace proceeds of crime, laundered money, such stringent provisions were in fact required. And we'll take a look at it in greater detail when we are discussing Section 45 of the Act. But the basic idea was that after Vijay Madanlal, a lot of other cases which had been previously decided by the High Court, which came to the aid of the accused person, was set aside. And in a way, the ED, the Act itself gave them a lot of powers. But after this judgment, the ED seemed to have even more powers. And if you became an accused person in a money laundering case, then from a defense lawyer's perspective, it became very difficult to protect your liberty, to defend your case, etc., etc. Now we come directly to Section 19 of the PMLA, and relevant here is 19(1), which basically states that if the director, deputy director, assistant director, or any other officer authorized in this behalf by the central government by such and such order has, on the basis of material in his possession, reason to believe, the reason for such belief to be recorded in writing, that any person has been guilty of an offense punishable under this Act, he may arrest such person and shall, as soon as may be, inform him of the grounds of such arrest. Now, this one provision, 19(1), has been the subject matter of a plethora of cases across this country. Several high courts have decided and interpreted this provision in their own way, and as a consequence thereof, there was absolute lack of uniformity in terms of what it means. And the reason for that is that while 19(1) echoes the language of Article 22(1), which is that a person who has been arrested will be informed of his grounds of arrest as soon as possible, it did not really spell out the manner in which it had to be done. So as a consequence thereof, what started happening was that in some parts of the company, in some parts of the country, whenever somebody was being arrested, they were being provided the grounds of arrest in writing. But in a lot of cases, they were either being allowed to just take a look at it or it was read out to them. Now, let us understand how it plays out practically, right? Because when we look at the language of 19.1, it says that before effecting any arrest, the officer must have reason to believe on the basis of material in his possession. Now, we'll discuss what this means in just some time. And as soon as possible, inform the accused of the grounds of such arrest. So the requirement is twofold here. The number one is that you need to have reason to believe to arrest someone, which has to be recorded in writing and it has to be on the basis of material in your possession. The second requirement is that you have to inform grounds of arrest, which are distinct and different from reason to believe to the accused person. Now, for the longest time, there was a lot of improper manner in which the ED was exercising this power due to the inconsistency in practice, due to the ambiguity in the law, and even Vijay Madanlal did not really clarify the manner in which this informing of the grounds of arrest had to happen. And naturally, as a consequence thereof, we saw a lot of wholesale, indiscriminate arrests being made, far-reaching attachments being carried out by the ED, allegations, multifold allegations where it's been alleged that the ED is being used to carry out political hits, so on and so forth. In fact, even the Supreme Court, in the case of Manish Sisodia, in the case of Arvind Kejriwal, has recorded in its order that there are these allegations, there are these impropriety concerns around the ED, and for this reason, the ED needs to conduct itself with utmost credibility, transparency, and fairness. Unfortunately, that was not happening. And we come to the very first case law that we have to discuss today. This is the case of Pankaj Bansal versus Union of India. Now, before we get into what the legal issue here was, let's just see the facts and the chronology of events which led to the case in Pankaj Bansal, right? Which will give us an indication as to the sort of misuse or abuse of power which may have been occurring after Vijay Madanlal and before Pankaj Bansal and a bunch of other judgments which have come in the last 3-4 years set the law straight. So in this case, there was an ECR which was registered by the ED on 15th of June 2021. Now this ECIR did not name Pankaj Bansal. Then on 7th June 2023, which is almost 2 years after the ECIR was registered, one Roop Bansal is arrested by the ED. Now Roop Bansal was named in the ECIR, Pankaj Bansal was not. However, because she was also a high-level executive, a shareholder in the same company Pankaj Bansal was, Pankaj Bansal and his father applied for anticipatory bail before the Delhi High Court. And on 8th June, which is one day after the arrest, they were granted interim protection by the High Court until the next date of hearing, which was 5th of July 2023. Then on 13th June 2023, I'm sorry, the dates here are wrong. It should be 2023, not 2025. On 13th June 2025, which is a mere 5 days after the High Court gave Pankaj Bansal protection in the ECIR, which was recorded in 21, the ED registers another ECIR. Now, in this ECIR also, Pankaj Bansal is not named. But on 13th of June, Pankaj Bansal receives a summons in connection with this ECIR, asking him to be present at the ED offices on 14th of June, which is the next day. On the next day, Pankaj Bansal goes, and late in the evening, after questioning him for some time, he's arrested in connection with the second ECI. Now, all of this was not looked at very kindly by the High Court, who had given interim protection to Pankaj Bansal in the first ECIR. And it came to the opinion that, and of course it didn't say it in so many words, but it came to the opinion that the second ECIR was insidiously registered on 13th of June, so that on 14th of June, Pankaj Bansal could be arrested in connection with this different ECIR, despite the protection of the High Court. And in its order, the High Court, this is the Supreme Court's judgment, and in its order, the Supreme Court did not flinch any words at all. It stated that this chronology of events speaks volumes and reflects rather poorly, if not negatively, on ED's style of function. Being a premier investigating agency charged with the onerous responsibility of curbing the debilitating economic offense of money laundering in our company, every action of the ED in the course of such exercise is expected to be transparent, above board, and conforming to pristine standards of fair play in action. So the Supreme Court was not lost on the Supreme Court as to what had happened. So when these petitions reached the Supreme Court, the issue was that the arrest was challenged on the ground, among others, that the grounds of arrest were not provided in writing to Pankaj Bansal, and therefore there was a violation of section 19(1) of the PMLA, thereby rendering the entire arrest illegal and invalid. Now, there were a lot of arguments made, and because there's a limitation of time today, we're not going to get into that. We'll directly move to paragraph 29 of this judgment, where the Supreme Court makes its observations with respect to the requirement of providing grounds of arrest. And the issue that was framed was, the more important issue is as to how the ED is required to inform the arrested person of the grounds for his or her arrest. Now, the Supreme Court reiterates that section 19 does not specify how this is to be done and how this aspect was not dealt with in Vijay Madanla. And then it also takes note of the fact that there is no consistent and uniform practice, and in different areas of the country, different practices are prevalent. And after this discussion, the Supreme Court holds that there is no valid reason as to why a copy of such written grounds of arrest should not be furnished to the arrested person as a matter of course and without exception. So through Pankaj Bansal, the Supreme Court made it clear that if you are exercising powers under section 19 and arresting someone, then such arrested person necessarily needs to be provided in writing with the grounds of arrest. And if that has not been done, then the entire arrest, the subsequent remand, everything gets vitiated on account of this illegality. Now, the reason why this is the case was twofold. The first reason, as per the Supreme Court, was that in the event such grounds of arrest are orally read out to the arrested person or read by such person with nothing further, and this fact is disputed in a given case, it may boil down to the word of the arrested person against the word of the authorized officer as to whether or not there is due and proper compliance in this regard. So the Supreme Court looked at it from a very practical standpoint. They stated that if grounds of arrest are not being provided in writing, and rather the practice which was adopted by ED in certain places where the accused was allowed to just read the grounds of arrest, dispute can subsequently arise whether there has actually been compliance with section 19 or not. And naturally so, because in any given case, even if grounds of arrest has been shown, not shown, the ED is going to come and contend that we have complied with 19. Whereas for the accused person, they are obviously going to argue that 19 was not complied. So if there is no evidence which is generated at the time of the arrest itself, this question of fact becomes his word versus my word, which is neither here nor there. Therefore, the Supreme Court said that grounds of arrest will be provided to the accused, and he will duly sign and acknowledge that he has received such grounds of arrest in writing. So at a later stage, it is not left open to doubt or speculation as to whether or not section 19 has actually been complied with or not. The second reason, as per the Supreme Court, as to why this would be the proper course to adopt is the constitutional objective underlying such information being given to the arrested person. Conveyance of this information is not only to apprise the arrested person of why she is being arrested, but also to enable such person to seek legal counsel and thereafter present a case before the court under section 45 to seek release on bail if they so choose. So the second reason, as per the Supreme Court, was that at the end of the day, 22(1) states that if I'm being arrested, I have to be informed of my grounds of arrest. 19(1) states that if I'm being arrested, I'll be provided of my grounds of arrest. And the reason for that is because the founders of our constitution, the fathers of our constitution, they were aware of the fact that this is a very basic principle. If today I don't know why I'm being arrested, in connection with what crime, what is the offense being alleged against me, what is the role being ascribed to me, I am in no position to effectively defend myself in a court of law, because I can't protect against what I'm not aware of. So the Supreme Court understood that this was at the heart of Article 22 of the Constitution, which has been mirrored in Section 19 of the PMLA, and therefore to not comply with it, to simply say that we are allowing the accused to read it, we are allowing the accused, we are telling the accused orally, etc., is not enough. Because if at the end of the day, when a person is being arrested, you are showing him the written grounds of arrest, you are reading out the written grounds of arrest, then there should absolutely be no problem in providing a copy of the same to him. Because at the time when a person is being arrested, naturally they're in a deep state of shock. 20 different things are unfolding together as they speak. So for them to be able to capture complex, complicated things written over 3-4 pages by simple reading or simply being orally informed is a little absurd, to say the least. And this is what the Supreme Court also understood, that I'll just read out the part. More so, as a person who has just been arrested would not be in a calm and collected frame of mind and may be utterly incapable of remembering the contents of the grounds of arrest read by or read out to him or her. The very purpose of this constitutionality and statutory protection would be rendered nugatory by permitting the authorities concerned to merely read out or permit the reading of the grounds of arrest, irrespective of their length and detail, and thereafter claim due compliance with the constitutional requirement under 22(1) and statutory mandate under 19(1) of the Act. So the Supreme Court said exactly what we just discussed. And after Pankaj Bansal, as held by the Supreme Court in paragraph 39, it would be necessary henceforth, that is the date on which the judgment was passed, that a copy of such written grounds of arrest is furnished to the arrested person as a matter of course and without any exception. So this was one of the first judgments that came out in recent time, which was very beneficial to the accused persons, because there were several cases where people were being arrested, 10-pager documents were being just read out to them, and then they were expected to defend themselves in the remand hearing less than 24 hours later, which was naturally very difficult, and it was being intentionally done to put the accused persons in a more disadvantaged position to make them unable to defend themselves adequately. And the Supreme Court naturally took note of this. They took note of the fact that Article 22 is very clear in what it wants, in the consequence that it intends, and accordingly gave its interpretation of 19(1). And since Pankaj Bansal, grounds of arrest are being provided in written to the accused persons immediately at the time of the arrest. Now, there are several other benefits also which stem out of it. And these benefits were discussed in the next case, which was the case of Prabir Purkhayastha versus State of NCT of Delhi. This came in 2024. And this was a judgment not under the PMLA, but under the Unlawful Activities Prevention Act. However, both the UAPA and the PMLA, so far as the arrest provisions are concerned, are para materia to each other, which is what the Supreme Court held in Prabir's case. And thereafter, relying on Pankaj Bansal, stated that even in UAPA cases, at the time of arrest, grounds of arrest have to be provided in writing to the accused person. And the decision was again tethered in 20, 21, and 22 of the Constitution. They specifically held that the right to be informed. Is my screen not visible anymore?
Yes, not visible.
Just one second. At paragraph 21 in Prabir's case, the Supreme Court specifically held that the right to be informed about the grounds of arrest flows from Article 22(1) of the Constitution of India. And any infringement of this fundamental right would vitiate the process of arrest and remand. And this, everyone, is very, very important because it's saying that if the initial arrest is illegal, unconstitutional for being violative of 22(1) of the Constitution, then any subsequent legal action which has taken place, be it a remand hearing or even filing of the charge sheet in the matter, would not validate the illegality and unconstitutionality committed at the time of arresting the accused. And therefore, everything else which followed would be set aside. So, if you are an investigating agency, these few judgments have made the requirement of providing grounds of arrest to the accused very, very important. Because if you fail to do that as an ED officer, then everything else that has come after it would be thrown out of the window. And from the accused's perspective, it has been very beneficial because right at the time of me being arrested, I will be told why I'm being arrested. Because the ED has to provide me the grounds of arrest immediately at the time of my arrest, I know that anything that they are bringing has been prepared beforehand. It is not something that they are winging, that they are whimsically making up simply because they want me to be arrested. So these judgments have brought more accountability to ED, and as a consequence thereof, more transparency and more fairness in the process. So that was being informed of the grounds of arrest and the two most important case laws in that regard. Now, before I move to the second requirement under 19(1), which is reason to believe, does anybody have any doubts that I can answer at this moment? Fantastic. So we'll move to the next segment, which is reason to believe. And this was succinctly laid down by the Supreme Court, leaving no room for ambiguity, no room for speculation in 2025 in Arvind Kejriwal's case. So the first thing the Supreme Court held in this judgment was that the reason to believe that any officer has to arrive at, as required under 19(1), isn't something that magically comes to him. It has to be on the basis of documents and oral statements which have been collected during the course of the investigation. So tomorrow, if that reason to believe that arrest is being challenged, then the officer should be objectively be able to satisfy a court of law that, look, here was the material which indicated at a prima facie level that the concerned person was guilty of the offense of money laundering. And I know it sounds very basic. It sounds like the most obvious interpretation of 19(1), but unfortunately for several years, that was not the case. The ED would arrest whimsically. The special court would agree to the arrest and grant remand mechanically, and then the twin conditions would be used to deny bail, and the accused person, despite the presumption of innocence, would continue to languish in prisons. So Arvind Kejriwal and the clarity which Arvind Kejriwal brought to the interpretation of key provisions of the PMLA can't be understated. So reason to believe. Now, what exactly is reason to believe? Like we discussed, it has to be an objective. Just 1 second. It has to be something which is objective, and it has to be more than mere suspicion. Now, this was discussed in detail by the Supreme Court in Arvind Kejriwal's judgment, And they refer to a Canadian judgment in the case of Gifford versus Kelson. And an excerpt from this judgment was reproduced by the Supreme Court. And it reads, when we speak of reason to believe, we mean a conclusion arrived at as to the existence of a fact. Of course, reason to believe does not amount to positive knowledge, nor does it mean absolute certainty, but it does convey conviction of mind founded on evidence regarding the existence of a fact or the doing of an act. Suspicion, on the other hand, rings uncertainty. It lives in imagination, it is inkling, it is mistrust, it is chalk. Reason to believe is not, it is cheese. So that's how the Canadian Supreme Court spoke of reason to believe versus suspicion. And this is what was reproduced by our Supreme Court in Arvind Kejriwal's case. And it's very simple, honestly. It is basically that you have some material as a consequence of investigation. You look at that material, and that material indicates the existence of a particular fact. And that is reason to believe. And this is what the Supreme Court held as well in Arvind Kejriwal, that suspicion requires lower degree of satisfaction. It does not amount to belief. Belief is beyond speculation or doubt, and the threshold of belief conveys conviction founded on evidence regarding existence of a fact or doing of an act. Given that the power of arrest is drastic and it violates Article 21 of the Constitution, we must give meaningful, true, and full play to the legislative intent. Existence and validity of the reason to believe goes to the root of power to arrest. The subjective opinion of the arresting officer must be founded and based upon fair and objective consideration of the material as available with him on the date of arrest. So if the officer is unable to satisfy the special court as to how the material in his possession leads to a reason to believe that the accused has committed the offense of money laundering, then the arrest will be set aside. Now, this sort of interpretation is also supported by the definition of reason to believe given in the BNS. So, Section 2, Clause 29 of the BNS defines reason to believe as a person is said to have reason to believe of a thing if he has sufficient cause to believe that thing but not otherwise. Again, it seems a little cryptic, but what it basically means is that if a reasonable man looking at the same documents arrives at the most obvious conclusion, then that is reason to believe. So to summarize what we have learned so far about Section 19 is, number one, the officer must have some material in his possession. Now, this material can be oral statements, this material can be documents, this material can be any other evidence which can be objectively tested, objectively scrutinized. The second requirement is that on the basis of such objective material, the officer has reason to believe that the accused has committed the offense. And the third condition is that upon being arrested, the accused is being provided in writing of the reasons, of the grounds of his arrest. If any of these things are missing, it becomes a ground for challenging the arrest. And even before getting into Section 45 and whether the accused is entitled to bail or not, the action of arrest itself would be set aside. So this is a step that comes prior to Section 45, because it's within the confines of Section 19 itself. Are there any doubts at this point? Okay, I just have one question. Is it because mere suspicion will not amount to arrest? Absolutely. Mere suspicion cannot amount to arrest, because then we'd become a banana republic. Now, one interesting thing that came up for consideration in Arvind Kejriwal's case is a concept of necessity to arrest. Now, it was argued on behalf of Kejriwal that apart from grounds of arrest and reason to believe and material in possession, there also needs to be a necessity to arrest before power under Section 19 could be exercised. In this regard, the Supreme Court noted two things. The first thing it noted was that unlike other offences, an offence under PMLA and in exercising arrest powers under PMLA, such arrest cannot be for the purposes of investigation. The only reason you can arrest someone in a PMLA case is that you are apprehensive, that the proceeds of crime will be dissipated, evidence will be destroyed, witnesses will be harmed, etc. But if the reason for arresting is merely because you want to investigate the matter, then you can't arrest under PMLA. That's number one. The second thing that the Supreme Court stated in this regard was that necessity of arrest, neither the words nor the concept, is anywhere mentioned in the language of Section 19. Grounds of arrest is, material in his possession is, reason to believe is, but necessity of arrest has not been mentioned. So is necessity of arrest something which needs to be independently satisfied by the ED before exercising powers under Section 19 or not, is a question which was framed by the court, and it was referred to a larger bench for consideration, and it is currently under consideration. But just to understand what this concept is, let us take a look at the facts in Arvind Kejriwal's case. So what happened in Arvind Kejriwal's case was that the last time he was questioned by the ED or any statement regarding him was given to the ED was a year prior to his arrest. So it was argued by Arvind Kejriwal's lawyers that if there is a statement in your possession since last year, and today you are coming and arresting me on the strength of this statement, then why did you not arrest me then when the statement was first given to you? Because if there was any real need to arrest me, then as soon as the information of some guilt on my part was made available to you, you should have arrested me. But you did not do that. Instead, you waited for a year and nothing new happened in this time. No new material was provided to you, but you came and arrested. So this gap, this non-existence of any new material leading to my arrest, raises questions as to whether there was any real necessity to arrest Arvind Kejriwal or not. And frankly, in my opinion, this is a very valid argument to make, because at the end of the day, and this is something that the Supreme Court has said as far back as in Menka Gandhi, that you don't only have to comply with the letter of the law, you must also comply with the spirit of the law. So if today Section 19 of the PMLA has inbuilt safeguards, inherent checks and balances, those checks and balances, those safeguards exist to protect against the drastic power of arrest, and arrest being a measure of last resort. So if that is indeed the case, then mere formalistically satisfying requirements that, oh look, I have material, I had grounds of arrest, I had reason to believe, should not be enough. The ED should also be required to show why arrest as one of the only outcomes that are happening right now was made absolutely necessary. But again, this is something which is sub judice before a larger bench of the Supreme Court, and when it's decided, we'll know exactly how the law stands. In the statement, arrests them. So there's a question that there may be instances where the ED summons witnesses and during the course of recording the statement, arrests them. How the reason to believe is formed on the basis of their statement, and does it not violate Article 23 of the Constitution? That's a very good question, and there are two aspects to it. The first aspect is, if somebody is being summoned as a witness, they are questioned, and after that questioning they are arrested, then where are the grounds of arrest? The second question is that in such a scenario, is Article 23, which is the right against self-incrimination, not violated? So the answer to the first question is that the testimony which is recorded of the said witness/accused during such summoning forms the basis of grounds of arrest. So if Today my client is called in for questioning by the ED. After questioning him, they arrest him. Then I will challenge the arrest merely on the basis of that statement, because my argument will be that before you took the statement, you did not arrest me, which indicated that there was no need to arrest me at such time. It was only after my statement was given to you that you decided to arrest me. So there must be something in my statement. And then I will go through my statement and I'll try to show that there was nothing in my statement which could have necessitated the arrest. But from a formalistic perspective, from a procedural compliance perspective, the ED can take the stance that after questioning this person, we formed belief that there were reasons to arrest him and they can arrest us. Now, the second question, whether arresting me on the basis of my own statement, which is you making me a witness against myself, not violate Article 23. So the answer to that question in the case of ED, as stated by the Supreme Court in Vijay Madanlal, is no. Because the Supreme Court held that the right to self-incrimination is available only against police officers. But ED, because its function is to trace and recover proceeds of crime, are not police officers. And therefore, any statement given to the ED will not be a statement given to a police officer, and therefore it will not be hit by Section 25 of the Indian Evidence Act and Article 23 of the Indian Constitution. In fact, if you do not answer truthfully under Section 50 of PMLA when questions are put to you by the ED officers, the ED can even initiate proceedings against you for not complying with their directives, etc., which will be akin to contempt of court actions. Although this position was diluted a little bit with Arvind Kejriwal when the Supreme Court stated that in ED, arrest cannot be merely for the purposes of investigation. If there are no questions, we'll move to the duties of the special court. Now, the duties of the special court were specifically called out again in Arvind Kejriwal's case. And the Supreme Court held that once the requirements under 19 have been complied with by the ED and the matter is placed before the special court has to independently verify and make up its mind. And the remand orders or any other order of the special court must reflect this application of mind on its part. If by looking at the order, it appears that it has been done mechanically, without appreciating the material, without properly applying their mind, then such orders will be liable to be immediately set aside. And I have personally seen that happen several times in the High Court and the Supreme Court. So an additional duty has been cast on the special courts to independently satisfy itself and not be mere rubber stamps who will agree to any remand request that is made to them. Now we come to Section 45 of the PMLA, which is the bail provisions essentially, and the infamous twin conditions. So what these twin conditions basically state is that notwithstanding anything contained in the CRPC, which is BNSS now, no person accused of an offence under the PMLA shall be released on bail unless two conditions are fulfilled. Number one is that the public prosecutor must be necessarily heard. You cannot grant any relief in the absence of the people. The second requirement, and this is where the issue used to come up in, is that where the public prosecutor opposes the application, which will be almost every single case, the court is satisfied that there are reasonable grounds for believing that he is not guilty of such offense and that he is not likely to commit any offense while on bail. So until last year, this condition basically meant that if I'm an accused in an ED case who has been arrested and I apply for bail, then I need to prove my innocence even before the investigation is completed. That is how harshly the provision was being interpreted, because the law was supposed to be stringent and it was being stringently applied. And naturally, the Supreme Court, the High Courts took note of this. They realized that too much power had been given to the ED and not adequate safeguards and checks and balances were there. And then came a few judgments which are very relevant, and we are going to discuss them today. So before we get to that, Vijay Madanlal upheld the constitutionality of Section 45. And they basically say this only, that law enforcement agencies should be provided with a proportionate, effective mechanism so as to deal with these type of offences, as the wealth of nation is to be safeguarded from these dreaded criminals. So the Supreme Court said that because money laundering was something which was detrimental to the economic interests of the country and therefore its sovereignty and its internal security, there needed to be such laws granting such powers which would be proportionate to the gravity of the offense that was involved. Having said that, the Supreme Court clarified nevertheless that it is important to note that the twin conditions provided under Section 45 of the Act, though restrict the right of the accused to grant of bail, it cannot be said that the conditions provided under Section 45 impose absolute restraint on the grant of bail. The discretion vests in the court, which is not arbitrary or irrational, but judicial, guided by the principles of law as provided under Section 45 of the Act. So the Supreme Court upheld the constitutional validity, said that it's not really impossible. You just need to satisfy the court, and the ultimate discretion is with the courts. So if it is with the courts, there is no question of arbitrariness or irrationality, and therefore the law as it stood at that time was valid and constitutional. Then came Manish Sisodia's judgment in 2024. And this was the first time where the burden of proof, which had been reversed by the twin conditions of 45, were taken back to their original form, even in the context of PMLA. The Supreme Court in Manish Sisodia held, they stated, from our experience, we can say that it appears that the trial courts and the high courts attempt to play safe in matters of grant of bail. This is a little concerning as law students, as young lawyers, because the Supreme Court is saying that high courts and district courts are playing safe in matters of grant of bail. The principle that bail is a rule and refusal is an exception is at times followed in breach. On account of non-grant of bail, even in straightforward, open and shut cases, this court is flooded with huge number of bail petitions, thereby adding to the huge pendency. It is high time that the trial courts and the high courts should recognize the principle that bail is rule and jail is exception. So the Supreme Court made it very, very clear that just because there are these twin conditions does not mean that bail becomes the exception and jail becomes the rule. It's just two additional requirements in addition to the bail jurisprudence already present in the country. And even in these cases, bail continues to be the rule. Now, this was absolutely made clear again in another judgment, Prem Prakash versus Union of India, wherein the Supreme Court, referring to Manish Sisodia's judgment, stated that it will be amply clear that even under PMLA, the governing principle is that bail is the rule and jail is the exception. All that Section 45 of the PMLA mentions is that certain conditions are to be satisfied. The principle that bail is the rule and jail is exception is only a paraphrasing of Article 21 of the Constitution of India, which states that no person shall be deprived of his life or personal liberty except according to the procedure established by law. Liberty of the individual is always a rule and deprivation is the exception. So, since this judgment, getting bail in PMLA cases has become easier. And the basic fundamental rights which sort of seemed lost when it became a PMLA case have come back into the fold again. And again, in Prem Prakash, the Supreme Court clarified that the court, while dealing with the application for grant of bail in PMLA, need not delve deep into the merits of the case, and only a view of the court based on the available material on record is required. It held that the court is only required to place its view based on probability on the basis of reasonable material collected during investigation. The words used in section 45 are reasonable grounds for believing, which means that the court has to see only if there is a genuine case against the accused and the prosecution is not required to prove the charge beyond reasonable doubt. So that is the law as it stands today, so far as section 45 of the PMLA is concerned. And that brings me to an end to the cases that I had picked out for discussing today. And if there are any cases, I'd be happy to answer them. Procedure for deprivation of life and personal liberty could not. So I have a question. Menaka Gandhi case, law prescribing a procedure for deprivation of life and personal liberty in Article 21 could not be any sort of procedure, but it had to be one that was neither arbitrary nor unfair nor reasonable. But in the case of ED, we hardly find such procedures being followed. So what's the scope of due process of law in case of PMLA? So that's a very wide question, and Satish is absolutely right in saying that in a lot of ED cases, we were not seeing such due procedure being followed by the ED, etc. And that is the reason why the Supreme Court stepped in as the guardian of our rights, of our fundamental rights, and interpreted the law in such a manner, in a harmonious, constructive manner, so as to balance the state's powers with that of the fundamental rights available with the citizens. So Pankaj Bansal, Prabir's case, Manish Sisodia, Arvind Kejriwal, Prem Prakash, all of these judgments are massive steps forward for Indian criminal jurisprudence in the context of PMLA, because it brings the law more in sync with the fundamental rights which are available to us. I hope that answers your question.
Definitely, sir. In theory, it answers, but in practice, we see something different. Definitely, whatever you have articulated, it's definitely correct. And even while reading the judgments, if we infer the letters and spirit, we see these things. But in case of practice, as we can understand, it become political. Just to quote one data, sir, the ED conviction rate, I think, is hardly 1% against the politicians. So it raises the question about the not just competency but the intentions as well.
Absolutely, Satish. I mean, and on a lighter vein, if everything was being done legally, then we lawyers would be out of a job. So that is why the judgments exist, that there is a massive gap between theory and practice. And when these judgments are delivered by the Supreme Court, it makes our job as lawyers easier in fighting for the rights of our clients.
Thank you, sir. Thank you for the fantastic session.
Are there any other questions that I can answer at this point? Fantastic. I think that's that then.
If anybody has a question, you may also raise your hand and you can directly interact with sir as well if that's what you wish. Or you could also put up the questions on the chat box. So I was here for a few more minutes. In the meantime, you can go ahead and ask your questions.
No, Disha, I am not going to share this PPT. Freezing and defreezing of assets under PMLA. Okay, so there's a difference between, so freezing usually happens for the police. There are search and attachment powers which are given under the CRPC, now BNSS. And then there are attachment powers given to the ED under the PMLA. So the manner in which it happens is that there is something known as provisional attachment which the ED does. And provisional attachment can be done for one of two types of properties. The first being direct proceeds of crime. So for example, I dupe banks of say 200 crores and I buy a 200 crore property, then that property becomes direct proceeds of crime. Second way in which I can do it is, for example, I already own a house, say 100 crores, and I defraud banks of 100 crores and I spend that 100 crores in God knows what. So the ED, when it finds out that I had taken 100 crores from the bank in fraudulent manners, proceeds of crime, and realizes that the proceeds of crime have been dissipated by me, then the ED can come and attach my assets which were not linked with proceeds of crime as value equivalent of proceeds of crime. Does that help, Vikram, Aditya? Burden of proof is no longer on the accused side. So that's what I was discussing earlier, that one of the twin conditions is that the accused person must satisfy the court that prima facie they are not guilty of the offense of money laundering. So the manner in which it was being interpreted was that courts deemed that it was now for the accused to show that he was innocent, as opposed to the investigating agencies showing that he is guilty. But as as Prem Prakash and Manish Sisodia clarified, that is not the case. The burden of proof will always be on the side of the prosecution, and bail will continue to be the rule even in PMLA cases. How far can be held accountable for mechanical remand orders lacking judicial application of mind? Hariom, special courts are being pulled up by high courts quite a bit of late as a consequence of mechanical remand orders being passed. And I understand, and Satish was earlier talking about this problem, that there's something in theory, and when we go to different parts of the country, something else is there in practice. But because now we have these laws and now we have these specific obligations cast on the special court, if there is a violation of those obligations by the special court, it gives us grounds to challenge the arrest itself. So now, unlike before, when the special court would pass a mechanical order of remand and we'd have no remedy, we now have the remedy of filing a habeas corpus petition before the High Court or the Supreme Court and saying that, hey, look, this is what they were supposed to do, but the order is a copy paste of the ED's report and there is no application of mine. And the Supreme Court, the High Courts will hear us and will give us relief. Erode the presumption of innocence. So no, Vedant, it doesn't erode the presumption of innocence anymore after what has been held in Prem Prakash and Manish Sisodia. And there's just a higher requirement there because the offenses involved are considered to be more heinous in nature. And because of such gravity of the offenses, it is considered proportionate to have such stringent provisions in place. Now, with the Supreme Court's interpretation of these provisions, there has been a fine balance which has now been struck. But of course, the judgment came only last year, and it takes some time for matters to reach the special court, get decided one way or the other before they can come up to the High Courts and the Supreme Courts and we get to know about it. So it still remains to be seen that despite the Supreme Court's intervention, how the law plays out. And a great example in this regard, I mean, everybody is aware of Shreya Singhal versus Union of India, where Section 66A of the IT Act, Information Technology Act, was held to be unconstitutional. And despite that, 10 years later in UP, the UP police is writing FIRs under Section 66A IT Act. So that lag between what is decided by the apex court and what is followed by the lowest ranking police officer in a remote village in India is very real. And it's only with more consultation, with my effort, and of course the guidance and the supervision of the constitutional courts of this country, that eventually we'll reach a point where the practice is what the law requires it to be. Can we say that while ED exercises its power to arrest, there is an element of presumption that the accused has amassed proceeds of crime? Yes, of course. If the accused person, so the question is from the investigator's perspective, can we say that while the ED exercises its powers to arrest, there is an element of presumption that the accused has amassed proceeds of crime? So there's no presumption. It is something which has to exist objectively. That is what it means, that on the basis of material in his possession, the officer will record the grounds of arrest, record his reasons to believe in writing. And until and unless an officer has reason to believe that someone has amassed proceeds of crime, he cannot go and arrest. In view of the expanded definition of money laundering, Section 3 include concealment. How is the demarcation to be maintained between civil or quasi-criminal concealment? In view of the expanded definition of money laundering under Section 3 of the PMLA to include concealment, how is the demarcation to be maintained between civil or quasi-criminal concealment of income or assets actionable under the Income Tax Act 1961 or the Black Money Undisclosed Foreign Income and Assets Act 2015 and criminal concealment attracting PMLA? So see, if the overlap between A and B in your question is quite a lot, in fact. So if there are proceedings initiated against someone under the Black Money Act, there is a very good chance that there is also an ECIR against. Now, from an income tax perspective, number one, of course, there's a difference between tax planning and tax evasion. Then number two is that under the Income Tax Act, there are several offenses which carry with them a civil penalty of fines, etc. But the moment a element of criminality is involved in it, and one of the predicate offenses under the PMLA are triggered, then the ED will have jurisdiction to look into the matter. So long story short is that the delineation between the concealment of income, which could be civil or quasi-civil, and criminal under the PMLA is limited or is circumscribed by what offenses are contained in the schedule to the PMLA. So if any given conduct under either the Income Tax Act, the FEMA, the PMLA, any other act, if that specific thing is a scheduled offense under the PMLA, then the ED will come into the picture. But if it's not a scheduled offense, then the ED can't intervene. Which holds more importance when it comes to ECIR and FIR? Sir, how do the provisions for bail under PMLA differ from regular criminal law? Okay, so under regular criminal law, 437 and 439 of the CRPC, the usual test which was followed was the triple test. What the triple test states is that if a person is not a flight risk, if the person is not at risk of threatening or intimidating witnesses, and if a person is not going to destroy evidence, then they are entitled to bail unless bail for the offenses which they have committed are specifically prohibited, such as murder, etc. Whereas under PMLA, in addition to the triple test, you also need to satisfy the twin conditions that we discussed under section 45 of the PMLA. Now, Twisha asks, which holds more importance when it comes to ECIR and FIR? So it's not an either or situation. Both of them have different domains of operation. The FIR is for an offense, which is not a money laundering offense. It could be an offense under the BNS, it can be an offense under the IPC, or any of the special statutes which exist. And this FIR is the starting point for any investigation which the police conducts. It's on a different footing. On the basis of this FIR, the ED can register an ECIR if the offenses in the FIR are scheduled offenses under the PM. So, in the context of your question, I think the FIR holds more importance because if there is no FIR, then there can be no ECIR. And the Supreme Court and various high courts have consistently held that in a case where an FIR also exists and an ECIR also exists, and the FIR is quashed by the High Court or the Supreme Court, then the ECIR also must go. So the ECIR owes its existence in a way, in a manner of speaking, to the corresponding FIR. So in real life, how does the wide meaning of proceeds of crime under the PMLA affect people or businesses who are only indirectly linked to a case? Have you handled any situation where this became a problem and raised concerns about someone's fundamental rights? Yes, I have been involved in cases where there is a person who's a genuine party, and I'll give you an example. I'm doing a string of cases like this, where my client is a bank and the accused person has approached my client, say 10 years ago or 15 years ago, for a large loan, and as security for the loans, they had pledged certain properties to my client. At the time of giving the loan and accepting these securities by my client, who's a bank, there were no criminal cases against the accused person. There was no reason why my client would believe that this person is a criminal, or the properties that he's providing me are properties which are tainted or which are proceeds of crime. And of course, my client carried out their due diligence as per RBI circulars, etc. And everything was spick and span. So the loan was given. Now, 10-15 years later, the borrower starts defaulting on the loans. Once the defaulting on the loans start, investigation into the matters begin. It's found out that sums were siphoned off, etc., etc. And then CBI comes into the picture and FIR is registered. The ED comes into the picture and ECIR is registered. And then when I, as the lender, start to monetize the securities which were provided to me, the ED comes in and objects and says, oh no, you can't do it because this is proceeds of crime. Or even before I can start monetizing it, I find that the ED has already attached it. So this is something which is a cause for concern, because everywhere the ED says that I need to attach this property because public money is involved. But I am a bank, and not only have I been duped of crores of rupees, but now you're telling me that the security which was provided to me is also not available to me because of XYZ reason. And at the end of the day, the money available with banks is also public money. So this is an issue, and there are a few judgments that have been passed in this regard, notable amongst them being Axis Bank versus Enforcement Directorate by the Delhi High Court. But there is an appeal pending against this judgment before the Supreme Court. So again, the jurisprudence is still being developed, and it'll be 5-7 years before we have absolute clarity on what is what. Applies in these cases in real life. Generally, when an accused is arrested, the person is considered to be innocent until proven. But in case of UAP or PMLA, why a person is guilty until proven innocent? So again, Disha, like we've been discussing through the course of this webinar, that position now stands diluted to a great degree. And the only reason that there are additional requirements is because there are additional stringent preconditions to the exercise of any powers under these special acts. So when these special conditions are being met by investigating agencies, some of their senior most officers are involved in giving approvals, etc., it is assumed that the material available with them is more than the usual material which is generally available with the police. So therefore, these additional requirements are there. But again, there's checks and there's balances. There are additional requirements from an accused's perspective that I need to satisfy 2 more conditions. But from the investigating agency's perspective, they also have additional requirements which you will not find in the CRPC or under the BNSS. So that is how the laws are framed, that when you have to deal with an issue which is a special sort of an issue, which is a graver issue than usual, and you require special legislation for that, then you will have these special provisions which will cut both ways. Sir, there is a... Does the theory of reverse burden of proof applies in these cases? I don't know which cases you are referring to. Next question is, sir, is there a case for creating an independent oversight body to review ED's arrest and attachment actions before they reach the courts? No, Hariom, there is no such thing like that, and that suggestion might not practically play out because this independent oversight body is basically the courts. That is the job of the courts. So there's no need for an independent body as such. Can PMLA be used against someone for holding cash above a certain limit without proven criminal origin? It will depend. So, like I mentioned, a PMLA case and ECIR can't come into existence unless there is an FIR in place. Now, an FIR can indeed be registered for a person having cash above permissible limits, and there are 20 different ways in which such a case can be made out. And if an FIR like that exists, then yes, the PMLA can come into the picture. Satish has his hand raised for a while. Please, Satish, what is your question?
Thank you, sir, for giving the one more chance. Actually, sir, I have the concern regarding the very definition of ED, like you explained, and even the Supreme Court or the other courts have interpreted that due to the very nature of work or the function that ED discharges, like they investigate the proceeds of crime, so it cannot be considered police. But this very notion, sir, it not just limit the scope of Article 23, which say कि self information is not allowed, but it from the point of view of jurisprudence, it also hits the doctrine of colorable legislation, which say what cannot be done directly should not be done indirectly as well. So you don't think this narrow interpretation somewhere hits this doctrine? And because anyway, we can say okay, police have larger role when it comes to investigation, but even ED nowadays, as the roles are evolving, because we if we once again see the jurisprudence, we are not just here to look at the law, but also the socio-political conditions. So as the role of ED evolves, so is it not the time to reconsider the very notion, the definition of
So,
ED?
Satish, too, I've understood your question, and that you make a very valid point, and there are quite a few lawyers and academicians who echo that sentiment that you have. In fact, this, along with a few other grounds, form the subject matter of the review which has been filed against the Vijay Madanlal judgment. And Mr. Kapil Sibal, among other things, is also urging the point that it is incorrect to say that ED officers are not police officers, because the sort of functions that they discharge are very police-like. And therefore, what you said, that what you cannot do directly, you're doing indirectly, etc., etc. So these points are being argued. The matter was in fact heard last week, and right now the Supreme Court is at the stage of deciding whether the review itself is maintainable or not. Once the maintainability issue has been decided, the court will look into the merits, and there are 4 or 5 main grounds of contention that they have challenged from the original judgment. So I think, like I said, the law is rather new in that sense, and there's a lot that is happening. Different circumstances are coming to the fore every day, which are being brought to the notice of our constitutional court. So it's only natural that the jurisprudence will evolve in some more time, and that evolution is already taking place. So if you're really interested in this, I would strongly recommend that you follow these review proceedings that are happening in the Supreme Court.
Definitely, sir, I will keep track
And
of these things.
Just to give a little more background into the original Vijay Madanlal Chaudhary judgment. So the sort of jurisprudence that the Supreme Court relied on at that time was jurisprudence which pertained to income tax officers, because even income tax officers were not considered to be police officers, and there were certain provisions under the Income Tax Act which required you to answer truthfully to any question put to you by an income tax officer. Similar provisions existed in the PMLA. However, when we look at sections 160 and 161 of the CRPC, which pertains to the police, we will see that the exception of 23 has been carved out in the language of 161 itself. Because 161 states that I am required to answer all questions truthfully except for those questions which have a tendency to incriminate. So, again, it is not for the courts to legislate. The courts can only interpret the legislation as it stands. And the distinction between the provisions of IPC and PMLA are rather evident. And the similarity between the provisions of the Income Tax Act and the PMLA are also rather evident. So, therefore, the Supreme Court naturally did its job of judicial review, which is giving effect to the intention of the legislation. So, if tomorrow the review is decided to be unmaintainable or for whatever reasons, until and unless the provision itself is declared unconstitutional, there is nothing that the Supreme Court or the High Courts can do, because that is the law that the Parliament has made for us.
Thank you, sir. Thank you a lot. Really, it was a very well planned and very well discussed session. I look forward for more such session from you and your colleagues, basically from your firm. And thank you, Legal Aspects as well, for bringing such fantastic sessions.
So Harihom has another question. You're welcome, Satish. Harihom has another question. Vijay Mallya being declared a fugitive economic offender under PMLA and facing asset attachments under Section 5. How does this continued absence from India exposes the limitations of PMLA in securing custodial jurisdiction and enforcing cross-border accountability? आपने लगता है podcast देख लिया है. But anyway, to answer your question, number one, Vijay Mallya has not been declared a fugitive economic offender under the PMLA. He has been declared a fugitive economic offender under the Fugitive Economic Offenders Act. This is a very small special legislation which exists, which states that if you are an economic offender and after service of summons, etc., you still fail to appear before the court, then civil attachments can be carried out against your properties in India. And the idea behind the act is that if you are not facing trial, then I will compel you to come face trial. That's the idea. Now, speaking of the limitations of PMLA in securing custodial jurisdiction, again, it is not the PMLA which comes into the play when an accused person is sitting outside India. The India and the UK have a mutual legal assistance treaty, and any extradition, any cooperation between investigating agencies between the two countries have to be done in accordance with the PMLAT, in accordance with the MLATs. And one of the key factors of MLAT is that extradition can be refused by UK if there is something which does not conform or comply with its internal laws. So of course, we have to satisfy the UK courts first that Vijay Mallya, if he's extradited to India, he'll not be persecuted here and he's required under genuine investigation needs and trials, etc. And if we can't do that, then I don't think it's a failure on part of the law, but it's a failure on part of the investigating agency to present its case in such a manner that it's convincing, regardless of which jurisdiction that case is being presented in.
Right. Are there any more questions? All right. Thank you so much, sir. First of all, on behalf of everyone here, we extend our heartfelt thanks to you for today's engaging and informative session. Your ability to draw from real world cases while simplifying legal concepts has made today's learning truly valuable for our audience. Thank you so much, sir, once again. To all the participants who are in the meeting, the feedback form has been shared in the chat box, and only if you fill that will your certificate of participation be issued. Please ensure your details are entered correctly as they appear on your certificate. Thank you, everyone. Stay connected with us for more such insightful sessions. Until next time, stay sharp, stay curious, and keep learning. Thank you all. Have a great evening. Thank you, sir. Thank you, everybody else.
Thank you for having me. Take care, guys. Bye bye.
People in the meeting, please fill out the form before you leave. It is on the chat box. If you've not filled out the form, we could not be issuing the certificates. I have shared the link once again. Please go ahead and fill it out. Please make sure that you leave only after you filled out the form.